around the judiciary this afternoon, confirmation that the two judges who were involved in the Seriti Commission of Inquiry into the arms deal are now being referred to the Judicial Conduct Committee of the Judicial Service Commission. The Deputy Chief Justice, Raymond Zondo, he chairs that committee, has written to two organisations confirming that Judge Willie Seriti and Judge Hendrik Musi will now be referred to that committee. The commission was instituted, the Arms Deal Commission that is, was instituted by former President Jacob Zuma. Its chair, Judge Seriti, said that it had found not an iota of evidence of wrongdoing in the arms deal. The High Court in Gauteng then overturned that finding. Paul Holden is the director of Shadow World Investigations, one of the organisations that lodged this complaint. Paul, good afternoon to you and thank you for your time. What exactly have you complained about these two judges?
We've complained about quite a wide range of bad conduct. Essentially what we've done is we focused on the High Court judgment, which, as you just noted, overturned the findings of the so-called Seriti Commission. And that judgment was absolutely damning. It found that the Commission had failed to conduct any sort of meaningful investigation into the arms deal, had failed to question witnesses, had failed to seek evidence, and its findings as a result were totally overturned. And we argue in our papers that the High Court's findings showed that both Judges Seriti and Judge Musi are guilty of, at the very least, incompetence, at the most, willful misconduct, and we're hoping that the Judicial Commission will agree with us on that.
I get confused myself. The Judicial Conduct Committee investigates. It makes recommendations to the Conditional Conduct Tribunal, and after the Judicial Conduct Tribunal makes a decision, it goes to the Judicial Service Commission, I think is the way it works.
That's correct, yes.
Let's try and sum it all up then. Do you believe then that Judge Seriti and Judge Musi did more than just make a mistake? Are you suggesting it wasn't just that they made a mistake, as judges do, that's why we have an appeal system? Are you suggesting that they actually did something wrong deliberately, which would be misconduct?
It's a slightly difficult question to answer because in that court case, there wasn't evidence that was discovered that specifically spoke to an agenda, why the commission was so bad. But generally speaking, I do personally believe that it probably was misconduct. There was no attempt to investigate. And part of that's based on the take of people who try to work with the commission. So there were a huge number of employees and witness leaders who tried to actually pursue an inquiry, and they all resigned in protest of the way the commission conducted itself. And every single time they resigned, they said this commission of inquiry is making no effort to investigate matters. And one of those people who resigned said that the commission was actually pursuing a second agenda, and that second agenda was to, in his famous words, shut up people like myself and my colleagues who were critical of the arms deal. So I personally believe that it probably was misconduct, and I'll be very interested to see how this matter is pursued and how that's judged.
Well, I mean, what was so interesting about it at the time was that phrase, not an iota of evidence. I mean, iota is literally the smallest sort of instant of matter that there is. It was a sort of a very resounding thing for a judge to say.
It was not just resounding, it was resoundingly absurd thing to say. And not by the time the commission had reported, you already had two cases, criminal cases that had concluded around the arms deal. The first was the Tony Yengeni case, and the second was the Shabir Sheikh case, which found very clear evidence that Shabir Sheikh was actively soliciting bribes from arms deal companies. The crazy thing, the report is a very surreal thing to read, the Seriti Commission report, because it leaves out vast things that are very obviously public knowledge. So a very good example of this is that Jacob Zuma is not mentioned in the report. He's not mentioned once in the findings, even though he is probably the most famous case of an arms deal-related corruption case, and he's going on trial next week, or he should be going on trial depending on what happens with his lawyers. And actually, when somebody brought up the Jacob Zuma case in the proceedings, Judge Seriti responded by saying, well, no, actually, you know what, I've read the judgment in that case, in the Shabir Sheikh case, and as far as I'm concerned, you know, it concerned matters happening after the arms deal, and it's not relevant to my inquiry. which is, again, a very surreal thing, because if you go and look at the underlying NPA indictments of Jacob Zuma and Shibia Sheikh, they have entire sections called The Arms Deal, where they set out across a couple dozen pages the links between the corruption trial and the arms deal. So it was an utterly absurd and surreal judgment, really.
Well, I was going to say, I mean, your memory will be better than mine. I haven't written books about it. If I remember, you actually have. But, didn't former President Jacob Zuma, didn't he meet Elaine Tattard? I mean, he was a French arms deal executive, if I remember correctly.
Absolutely. I mean, we have very, very compelling evidence that Jacob Zuma solicited and accepted a bribe in order to prevent an investigation into Thompson CSF, now called Thales, who are the co-defendants of Jacob Zuma now. And that was incredibly well ventilated at trial. And the thing that people forget when they, such a long time ago, and there's a lot of people for whom, they maybe weren't even born when some of this stuff was happening. But the Judge Squire's judgment, which found Shibia Sheikh guilty, was utterly, utterly damning. On the case of what they subsequently called the generally corrupt relationship between himself and Jacob Zuma, Judge Squire said that the prosecution hadn't just proved their case, but their case and the evidence for it was utterly overwhelming. It was an absolutely damning judgment. And the fact that the Seriti Commission failed to even look at that judgment properly is just a testament to how absurd the whole process was. And that's in addition to all its other failings, like, for example, not getting a single document from a single prosecutor overseas, inviting the most clearly implicated parties and then not asking them any questions. It would be like Justice Zondo inviting the Guptas to the State Capture Commission and letting them read a statement and letting them walk out. It was a really bizarre experience to experience.
I think Fana Hlongwane was one of those people, if I remember. And, I mean, no one's ever managed to get him under oath before or since. So, I mean, for your complaints to succeed, do you think it's going to be enough just that you or the committee or whoever prosecutes these things would be convinced that the two judges in this case actually deliberately ignored evidence? Or do you think you'll have to bring something else, some other evidence of wrongdoing, if you see what I mean? I mean, it's quite hard to sort of prove a negative, to prove that someone ignored something. But these are not sort of ordinary people. These are not, mere journalists and authors and activists we're talking about. These are two judges. Judge Seriti is on the Supreme Court of Appeal. So there's a sort of higher standard, I suppose, would go the argument. Do you think that it would be enough to prove that there was a deliberate decision to ignore evidence?
Well, I think that's already been proven, to be honest. I think the High Court judgment on that was utterly damning, in that the High Court judgment found not just that the findings didn't make sense, but the Commission of Inquiry had not conducted a meaningful investigation. And that included just not going to look for evidence. And where there was evidence, just ignoring it and overlooking it. I think that case has already been proven. But on a sort of a more technical level, when the matter does proceed to a tribunal, under the sort of prevailing act, judges don't necessarily have to be found. There's no sort of hierarchy of misconduct, in a sense. They can either be found guilty of gross misconduct or gross incompetence, and they both sort of carry the same resonance in terms of their potential punishment and the potential embarrassment they'll suffer, and also some very practical things that might happen to them, like being stripped of their judgeships. So I'm not sure that we technically need to prove their case, but I feel like it already has been proven.
And the arms deal itself, I mean, memories are fading, as you've mentioned. We have the trial of the former President Jacob Zuma due to start on Monday, but of course he doesn't have a defense team. So it's I don't know what's going to happen on Monday, frankly, there. Do you think we're ever going to get to the bottom of what really, really happened?
It's a tough question. My sense is that we actually know quite a lot about what already happened. The arms deal is actually quite an information-rich scandal. We've presented, when myself and Andrew Feinstein made submissions to the Seriti Commission, our submission was, a couple hundred pages long, and we submitted evidence that ran into the tens of thousands of pages. We think that we've actually proven a lot of the corruption, or as it is, and I think we actually have a very great sense of how the arms deal played out, which is that we have European suppliers who basically came to South Africa and actively sought to solicit and offer bribes to key decision makers, and then it ended up with this terrible white elephant that still sits as a burden on South Africa's fiscals. That said, I still have a great deal of hope that the newly renewed MPA, after the Jacob Zuma matter, will turn to some of the other matters. Because while Jacob Zuma is a very important case politically, and it's a very important case to send a message that even the former president of South Africa can't evade justice forever, the amounts of money that were paid to Jacob Zuma were relatively small compared to some of the other players in this case. And that, for me, still needs to be pursued and investigated. And I hope that once the Jacob Zuma trial concludes, that will be done.
It's a fascinating story. Well, thanks very much indeed, Paul Holden. Do appreciate it. The time from the organisation Shadow World Investigations.